Welcome to Looking at Legal Stuff. Today we have 10 hearings in a case with a couple where Dad was ordered to do a mental health evaluation, but he's been refusing to do it. All the while, he files frivolous motions against his ex that are designed to harass and annoy her, dragging his feet the whole way. Her lawyer asked the court to require him to have to submit his motions to the court for review first before being allowed to file them. Let's see what the judge thinks. This update contains a missing hearing at the beginning and 2 short new updates, as well as some info about upcoming hearings in 2025. There will be links in the description box to the updated parts.
Any other cases, or I'm just going to start at the top and move down the list?
Judge, I'll take one that I promise you will be quick.
Okay.
That's Hitchcock and Hitchcock number 6. Review of discovery answers from Mr. Hitchcock.
Yes, 21-300-35808.
And we did get some of his answers, although not entirely complete, but for purposes of today, what we do need, Mr. Hitchcock, just actual pay stubs, bank statements, and the W-2 from 2022.
Hold on. Go slower, write these down.
Pay stubs, bank statements.
I gave you my
W-2.
I gave you W-2. I gave you my most recent bank statement, and I've given you all of my pay stubs. Well, I've given you my year to date. What?
I guess we can file what we have, Your Honor, then, and set this out for 2 weeks if you want to review it. It just needs to go away. We just need that honed in a little bit. We got some earning type information, but I wouldn't call that a pay stub. It's rather just kind of shows, it looks like it was even maybe self-prepared. Didn't get the W-2 from 20.
Hey, Mr. Chad. Hitchcock, do not interrupt, please.
Okay, I will take my rebuttal time when I get it.
Thanks, I appreciate it. Mr. Zandy, go ahead.
So actual pay stubs and the W-2 from 22, and I didn't see any bank statements. If it's in there, I can relook, but I didn't see any. And then just a roughed out value for what he thinks the properties are worth. And I think that's what we need.
So that's what you're still waiting for?
Yep.
Okay. Mr. Hitchcock. You're muted. You're muted, so you would need to unmute so I can hear you.
All right. Yeah, I've given all my pay stubs to Chad. I find it very offensive that he says that they look like they're self-prepared. It is 2023. I don't get pay stubs. It's all online. I've taken shots of that. I don't get paper pay stubs. I've given you every pay stub I have, Chad. I mean, I didn't give you every pay stub. I've given you year to dates for the end ones. So you have the most recent. You have the total incomes that I've earned, like for the past 3 years. What we do not have is any pay stubs for Megan Hitchcock. It has been 20 months since we filed for divorce. It has been 2 years and 5 months since we unofficially separated, and we have no pay stubs from Megan Hitchcock. We have no financials from Megan Hitchcock. We have nothing from Megan Hitchcock.
Yeah, so we're reviewing the motion to compel for Mr. Hitchcock. There hasn't been any formal request for discovery from my client. We get that. I will certainly prepare that and get that out, but that's well beyond what we're here today for.
Your Honor, when we first came for temporary orders, there was a disclosure of income. Megan did not disclose that she was working for Spectrum. She made herself sound like a hapless victim that couldn't find work because she had previously been a stay-at-home mom and she was already working for her high-paying job. So just the basis of going to temporary orders to start with, there's been a neglect, a denial, and lying of what's going on. I request that we get pay stubs and financials from Megan because she's hiding that.
Mr. Zandy, when there was, I don't know if you've been counsel record for Ms. Hitchcock this entire case. I know that Mr. Hitchcock was previously represented. And it appears as though those requests were made 2 years ago, December of 2021.
Chad was the lawyer at the time.
Yeah, I've been involved since the beginning, Judge. I think Mr. Hitchcock's gone through 2 attorneys off the top of my head that I can think of, maybe 3.
Does that have anything to do with scope, Chad? Two attorneys.
Okay. This isn't a buddy pal Chad situation, so he can be Mr. Zandy. And I'm calling you Mr. Hitchcock. I'm not calling you Mark.
Okay.
We're in
Thank
a
you.
court. This is Zoom, I understand, but this is a courtroom.
I do oppose that this has any scope about what's going on.
Well, we're here to review a motion in order to compel that was filed by Mr. Zandy.
Yes.
I don't
and-
have any motions filed by you recently if there's ongoing discovery concerns on your behalf.
But you did say, Your Honor, that, I mean, she should have at least started with her financials to begin with. One.
Well, and I don't know if that's something that your previous attorney still has and can turn over to you.
No, Megan has hidden that she was working for Spectrum.
Okay, well, then you need to make a formal request for discovery. If you need to ask for a motion to compel, you need to ask for a motion to compel. You're representing yourself, and I have to hold you to the same standards as I would if you were represented. So I can't give you legal advice, but I can tell you that certain things need to happen in order for the court to make a ruling on something.
Yeah, Your Honor, I did give Mr. Zandy all the pay stubs of every money I've earned. There will be some income that I have not earned, but that's going to come forward. But then he asked for bank statements, and I gave him my most recent bank statements. So he's asking for every bank statement for the last year, and that's going to include like my minute purchases of where I purchase things and where I go out to eat. I don't feel like that's appropriate.
Well, the only thing I can tell you is that's standard. So that's a common request that is very often complied with in its entirety.
How do I get bank statements for every month? That's like pages after pages after pages.
For your bank records. I know how I would get mine, but I don't know how you're going to get yours.
Well,
Hold on, Mr. Hitchcock. Mr. Zandy, what exactly are you missing? So I'm still unclear.
If we had the bank statements, that would go a long way. What we're trying to do is match up the incomes. He has switched jobs. I believe it was during the course of last year. So it would be nice to trace the incomes. Most notably, how you do that is through the complete pay stubs, match that up with the bank statements and the tax returns. And those are the 3 things you got that kind of clarifies any income dispute. So that's what we need it for. And I do that in probably 90% of my divorce cases, as I think is pretty common practice. So that's why we need that. And that's why we only went back for a year and not 3 or 5 years like some other folks do on this docket. Just to not try to be unreasonable, just want to be able to move this case along. We can't do that until we can certify that the discovery is complete. And at this point, we just can't do that.
Okay.
I don't want to come back. I just want the information so that I can rest on that and we can go to a mediation or a trial and we have everything and not have to have any holes with that.
Okay. Knowing why he's requesting that, is there any concern that you can get that provided to Mr. Zandy in a timely fashion, Mr. Hitchcock?
Yeah, I'm really unsure about the whole thing. But yeah, I mean, I can, and Mr. Zandy, you're welcome to email me. And I will be doing those motions for your client, but you're welcome to email me any questions you have. Yeah, like I said, I can be direct with you. I can be transparent with you, Mr. Zandy.
All right. So here's where we're at. I'm going to expect that the bank statements for a 1-year period will be provided. Sounds like pay stubs, according to Mr. Hitchcock, have been provided. And if there's any tax returns that have not been provided, need to be provided.
And I did tell Mr. Zandy that I haven't filed taxes and it's been like 3 years. I'd have to work with Megan to file, and that's been very difficult.
And do you have any documentation about extensions or anything of that nature?
No, we always get money back, so there's no big deal with extensions. Like, they don't ever penalize you if they're giving you money back, which we've always filed late, never this late. But once again, like, I mean, Megan doesn't. I ask her about the kids' school, and she doesn't answer me. I ask her about anything, and she just doesn't. She doesn't respond to anything.
Well, I'm sorry to hear that. That's not before me. The only thing that I've got any
And
history in this case for is this discovery request
I'm just saying,
that came last month, or excuse me, in January. So
I would need help and documents from Megan's side to file, and
okay. Well,
Yes.
sounds like you know what Mr. Zandy needs. You know why he needs it now. I'm going to expect that you're going to get those to him in a timely fashion, and you'll work with him to get those done. And if there's any other issues, it can be brought back before the court. And then I'm assuming I'll see you again on your motion, Mr. Hitchcock.
Yep.
All right.
Mark Hitchcock and Megan Hitchcock.
Yes, Your Honor, I was coming before the court to ask for the temporary restraining order to be dropped. I'm not a danger to, I'm absolutely not a danger to my children. I'm not a danger to my soon-to-be ex-wife, or anyone for that matter. And it is blocking me from even knowing about how they're doing in school. And as I mentioned, I don't know where Megan's emotions are coming from, but she has not told me where Liam goes to school. She refuses to answer any questions about the kids. So I'm just trying to do what I can to be in their lives.
All right, there's also let's see here. Okay. Okay. Thank you, Mr. Hitchcock. Ms. Bliss, are you on this, or Mr. Zandy's on this?
No, it's me, Your Honor, and to please the court, I do represent the respondent, non-moving party to the motion before you today. Megan Hitchcock, we did file for your review my client's responsive declaration to this motion back on March 20th. And I think she lays out some pretty significant grounds for why she's asking the order to remain as is. I would note, from a legal and factual basis, we think the affidavit on its face is insufficient. I don't think it complies with what the law is as it relates to that. It's the restraining order that was entered last summer by Judge Hahn. And this is a case in which at the time Mr. Hitchcock was represented by counsel. Both of them appeared at the hearing. Mr. Hitchcock submitted a 9-page declaration on his behalf, which pertains in large part to the request for not only the restraining order, but also as it related to the care and visitation of the children in this matter. And the court found sufficient grounds to grant the restraining order, and to suggest that that be set aside because he had insufficient notice, again, flies in the face of reason. Also doesn't comport with what the pleadings will provide for you, which is he was present, as was his then attorney. Now, there was no motion for reconsideration. Matter has sat idly by since it was entered back in August. And again, here we are now in March, Mr. Hitchcock representing himself, asking for a relief that just isn't afforded under the statute. My client does give you grounds for why we believe that that should remain in place. Now, this is a case in which Mr. Hitchcock was court ordered back in the summer to undergo a psychological evaluation, with input from the GAL, who is Ms. Height, as well as my client. And to date, my client has received no information pertaining to that. Now, she hasn't been contacted by any providers. We certainly have not received any kind of written documents or any kind of evaluation on Mr. Hitchcock's behalf. And that is still largely up in the air and has not been complied with. At minimum, we should see what the results of that psychological evaluation are before we address these types of issues. My client also gives you information about the snowmen. Understand after reviewing Mr. Hitchcock's mother's declaration that she's claiming to be the person who dropped those off at the home, but that was obviously concerning to my client, in which she responds, returns to the home after dropping the kids off at school, and there's on a day where there's no snow in the lower elevations of Longview, 3 snowmen, checks the video cameras and views what she believes is Mr. Hitchcock's car pulling up, and someone who's can't be ascertained who it is, and puts 3 snowmen on the front yard while the kids are at school. That's highly unusual. That's bizarre. There's been other communications that have her concern related to Mr. Hitchcock. As she states for you in her declaration, there is fear from her that he continues to surveil her about her comings and goings and where she's at. Continues to violate the order, and the order is very specific. The only communication is over the parenting app as it relates directly to the children. And Mr. Hitchcock is basically trying to relive old memories with her, again, addressing things related to the relationship and the past relationship during the marriage. And again, my client obviously has a sense of uneasiness when it comes to that. Now, given where we're at on this, doesn't make a lot of sense from my client's perspective to eliminate this or terminate the restraining order, which again has been in effect for some time. If you look at the terms of that restraining order, you'll see that it's set to expire in late May of this year. Again, that's 2 months away. One could logically assume that it probably makes the most sense in judicial economy to just let that ride itself out until May, work towards getting that psychological evaluation, seeing what the results of that are prior to making any decisions on this. But again, this kind of goes to my client's concerns about Mr. Hitchcock's emotional, mental well-being at this point. And we're at a point now where we're erring on the side of caution and safety. That makes the most amount of sense, and that's what my client is asking you to do today. We do believe this is improperly before the court. This is now the 3rd time we've been here in the last month and a half or so. Court did not impose any fees at the past 2 hearings, which were related to discovery issues from Mr. Hitchcock. We are asking the court to contemplate some award of attorney's fees and costs. It also informed the court, as you probably know, that there's now a pending another compel motion that Mr. Hitchcock has filed on his behalf. Instead of consolidating these matters and hearing these in one judicial proceeding, we're now forced to come back not only today, but again in a week or 2 on the compel motion. It comes at an expense to my client. She simply can't afford it. We are asking for a contribution towards fees and costs.
Your Honor.
Mr. Hitchcock, before you speak, I'd like to hear from Ms. Hyde.
Good afternoon, Your Honor. I do believe that it's going to be in Mr. Hitchcock's best interest to get that psychological evaluation. I think that will provide tools for him going forward that will help him in the future when he parents these children. So I feel like we need to wait until we get that. I think it's going to be in everyone's best interest. I did review the information about the snowmen. Frankly, it seemed silly to me that it became an issue. The picture that I saw was basically a few snowballs in somebody's yard. It didn't seem threatening at all. However, I do understand that having him or someone on his behalf, if that's what happened, show up, that is troubling and should not happen. I'm not sure that there was any kind of evil intent by grandmother's part. I think it sounded like kind of a spur of the moment idea of hers, and I don't find it particularly troubling. However, I don't think that rescinding the orders that are in place now are in the children's best interest at this time.
Thank you. Mr. Hitchcock, you may respond.
Your Honor, just allow me to compose myself. I'm sorry for laughing earlier. Earlier in this motion, not in this motion, earlier in this court, we heard somebody talking about a psych evaluation that was ordered December 7th of 2022 that they have not had that yet. The psych evaluations are out over a year. I got on the list as soon as I can. Ann knows that. Confused why Ann is here speaking on behalf, because she told me that she's done with this case. Furthermore, I've never broken that restraining order. I'm not crazy or dumb enough to go anywhere near Megan. I only found out that my mom did when I got Megan's responsive declaration. Again, I will go back to the original matter when she did write her declaration. She did perjure herself, which she does over and over again. But she said that Ann Height directed her to not bring my son to visits, and he wasn't coming. And then she made excuses for that after it came forth that that Beth Fellows didn't have her. So she took this on herself to keep my son from me in my supervised visits, and then used that as an excuse to further push me away from my children in a restraining order. As well, the fact that she says that she has video evidence where she clearly sees my car. And then again, where she says that she is certain that I'm surveilling her. Your Honor, I have had that car since July of last year. Megan and I we've not seen each other since that time. The only way Megan knows what my car looks like, one, is to surveil me, and two, my car was not there. It was my mom's, as she said. And there's been like 3 times my mom has driven my car, and I asked her, she said she's certain it wasn't my car that she took that day. Then when I revisited Megan's testimony to find out where I was, what I was doing, she says on February 20th, the kids had late start due to weather. February 20th was President's Day. There was no school. And before I found that out, before I realized that, I checked, and I was out of town that morning of the night before. And then I did call the school, and I just called Long Beach School District, because once again, Luke's school won't talk to me about how he's doing or what's going on. They said the only late start was February 16th. That day as well, I was out of town. It's not my car. Megan purposely, once again, she is lying about this video. Neither my car nor I was there. My mom and I both have a red sedan, but it's very different. My mom drives a 2007 Chrysler Sebring. I drive a 2018 Ford Fusion. Once again, I've never broken that restraining order, and my car was not there. And once again, Megan's doing everything she can to push me away from these children. Luke is 5, Liam is 4. Mario will be 3 soon. Every time I see Liam, he has to come to my house. Luke sometimes cries when he leaves visits. I'm concerned about their well-being, and I'm just trying to check up on them at school.
All right, thank you, Mr. Hitchcock. So we're not here to decide whether the restraining order is entered in the first place. That was determined almost a year ago on whatever facts were before the court at that time. I didn't make that decision, but I come to this case with the restraining order already filed. Mr. Hitchcock has asked that be dropped. I'm going to deny that request for 2 reasons. One is it's going to expire on its own terms on May 24th. That's not that long from now. And it may happen, it may not, but if Ms. Hitchcock asks for a renewal, then all of the arguments that Mr. Hitchcock has discussed with us today would be relevant in that discussion. But because it's going to expire relatively soon, I think it should remain in place. Secondly, both Mr. Zandy and Ms. Hyde have indicated that there needs to be a mental health evaluation. I did see that in the file, and apparently one has not been done since it was ordered. And the court is hesitant to make any changes until that evaluation is done. So what I would suggest, Mr. Hitchcock, is I think you should get the evaluation done. I think you should anticipate that Ms. Hitchcock may be asking to renew that restraining order. And it will be helpful to the court to have a mental health evaluation done before ruling on that renewal motion, if it's brought. But I think we should look ahead, and I'm going to encourage that you get that done as soon as possible. Otherwise, for today, I'm going to deny the motion to lift the restraining. Okay.
Could you just enter a bench order to that effect, Your Honor, so we don't have to come back?
I will do that.
What does a bench order do?
It's an order that I draft that will say simply that I denied the motion to lift the restraining order.
Okay. I do want to say for the record that what Megan is doing is hurting these children, and that is my primary desire, is to help my children.
Okay, I accept that, sir. Okay,
Thank you.
thank you.
All right, any other
Your
any other
Honor,
quick matters or strikes?
Your Honor, I believe we have a hopefully quick matter in Hitchcock versus Hitchcock 213-0035808. I tried to talk to Mr. Zandy's legal aid. The only thing I'm looking for, the only reason we're here is to get that subpoena for the records from our marital counselor. It was key in the GAL's decision of what went on. So we're just trying to clear that up and get that so we can totally find out what was actually said by that counselor. That's the only thing we're here for. Everything else can take its time. Mr. Zandy?
Your response to that, Judge?
Yeah, I saw there was a motion to compel, and I reviewed that. And I reviewed the response. I didn't.
They got the video, so that was one motion to compel. The other one was finances, and Megan saying she wants more time with that. It sounds like the only other thing is that at this moment is the subpoena. Megan said in her to the guardian ad litem to Ann Height that that counselor had kicked us out of counseling because of my actions, and made decisions based upon those things and other things that counselor supposedly said, but they were never verified. So we're trying to get those records. That's all we're doing.
So in response to this, I really don't know what it is he's after, what he's doing. Behind the scenes, we're trying to give him and accommodate him what he's asking for via email. There's never been a formal request for discovery. There's never been interrogatories exchanged. I'm not sure about the subpoena. I didn't see that, or I think in his materials that he provided for today. There's been no CR26I conferences. There's been no formal request whatsoever made by Mr. Hitchcock or through his prior counsel. We're really concerned at this point. Like, this is getting out of hand. This is now the second time we've been here in 3 weeks for motions that frankly didn't have a legal or a factual basis to be brought. We tried to kind of insinuate in our response that this is improperly before the court, that you don't ask the court for a subpoena. You have to go through the appropriate routes of discovery. Yet here we are. I do understand that Mr. Hitchcock did have a conversation with my legal assistant this morning. I've been made aware of that. The docket this morning never got over for me until about 12:30 or so. So I'm trying to, again, gather what information I can, but we were just here 2 weeks ago on a request by Mr. Hitchcock to rescind a restraining order. The court readily dismissed that, only to be then served around the same period of time with this motion to compel discovery that I still have really no idea what it is he's asking for. Again, we're trying to.
Why are we here?
Yeah.
Mr. Hitchcock, you always interrupt. Nobody interrupts you. So please don't interrupt anyone else. Go ahead, Mr. Zandy.
So again, I mean, from a procedural standpoint, none of this is appropriate, but this is now fourth time we've been in court, largely to Mr. Hitchcock's doing, and my client quite literally is going backwards on the fees. So we are asking for a contribution, and then again, just kind of a strong message that this isn't appropriate. This is borderline abusive at this point.
Your Honor, can I speak now?
Well, no one else is talking, so yes, you can.
Your Honor, these claims were made to the Garnet lineup. They were primarily the reasons why I'm on supervised visits. I've spent over $5,000 in supervised visits. I've lost over 100 days with my kids. I don't know why we're here. Chad could have emailed, or sorry, Mr. Zandy could have emailed motions to compel. I mean, they could have been answered. I said that this morning. I said, all we need is, we just need to agree on this, on getting the facts of what the counselor said. If the counselor said what Megan said, then that makes sense of, what's going on. But if the counselor did not, which is what I attest, I mean, this entire case, my supervised visits, the $5,000 I've spent, the trauma it's caused my children, it's all in naught. And it's all been pushed by what I believe is clearly lies. I know that the counselor didn't kick us out because of that. Megan stormed out of the session. Megan stormed out of the last session, and then she blamed it all on me. And then Ann just believed her. I believe Ann's here, but this hasn't been justice. These kids are suffering because of these lies. Megan has repeatedly lied. We know that. We've seen that. And these kids,
Well,
they're
yeah. We're here on Mr. Hitchcock's motion and docket notice for a motion to compel. That's why we're here. And all this is well beyond the scope of discovery issues.
Mr. Zandy, either you're covering for your client. There's no reason why you would.
Okay, so I'm done right now. So a couple different things. If you were involved in this treatment, then you should be able to access the records yourself. If it was marriage counseling between the two of you and you were both there, then those records are just equally as yours as they are hers. So you should be able to access those directly from whatever that counselor is. I'm still talking. Secondly, this isn't the proper format to do this. You can't compel someone to produce something when you haven't formally asked them to give you that stuff. Mr. Zandy is indicating that has not happened in this case. So it's really prematurely before the court to compel them to do something when you haven't formally asked them to do it outside of the purview of the court. So those are the two responses I have. I understand the frustration that you may have. I understand the frustration Mr. Zandy may have with this case. It's always kind of every time that you're before me, Mr. Hitchcock, it's everybody else's issue but your own. I understand you're frustrated. I sympathize with that.
Your Honor, Megan lied.
But I'm still talking, Mr. Hitchcock. I don't know that she lied. So I'm taking your word instead of somebody else's, and we have a neutral third party that looked into all of this, and that's where we came out. I don't think I was involved in that portion of your case. I've only been dealing with the last couple months of your case, but at this point, I'm going to deny your request. If you make a proper request for that information and are unable to get it, then you're in a position where you can move to compel that information to be provided. But the onus isn't on Mr. Zandy or Ms. Hitchcock to provide that if it's records you can get yourself. And if it's mutual counseling, then you're both have equal rights to those records.
The counselor denied me getting them.
That makes zero sense whatsoever. I don't know if Ms. Height would be able to discuss that because their ROIs were all entered, it appears, based on my review of the GAL report. So I'm denying your request. As part of request of the petition or fees to the petitioner, or excuse me, to the respondent, they're asking for $2,000 in fees. I almost feel like I should grant that because we're here for a lot of things. And I understand that you're not an attorney, but you're held to the same standard as an attorney when you're representing yourself. And we're here on things that we shouldn't be here on. So I'm not going to grant $2,000. I'll grant $500 in attorney's fees.
Once again, if Mr. Zandy would have emailed me and talked to me.
Great. You keep working with him on that.
And technically the main compel I'm here for is to compel Megan's wages from over 2 years ago. That was the actual
The thing you
Thank-
just told me is the only thing we're here for is the records from the counseling. And now all of a sudden you're talking about compelling records for finances. Have you asked and done a formal request for those through Mr. Zandy?
And you said the last time we were here that was officially, asked for in the initial asking, like
Okay,
the fact.
well then we're done with what we're here for. All right, so I'm gonna deny your request. I'm gonna impose $500 in attorney's fees.
You want to set a presentation date?
If you'd
Or you
like,
want to just
we
enter
can,
a bench order?
What's the
I
presentation?
I can do a bench order, that's fine. I'll just make a
What's
note
that?
to myself.
Thank you.
Right, Hitchcock and Hitchcock. That's 213-0035808.
Matter's ready, Your Honor.
All right. I have relocation and taxes are on the list of items to discuss today. And I did receive materials from both parties and I see everyone present. So Mr. Zandy, I will start with you.
And I would submit, Judge, that I understand Mr. Hitchcock did submit some materials after that. It's my understanding he notified my office and said, well, some of them didn't come through, but you've already got it. It's stuff that's been included in the past. And then most recently, we were served, I want to say last night or this morning, it looks like a request for a continuance that he addressed it to Your Honor. I'm requesting a continuance for this motion to get a lawyer. Regardless, I don't think any of that is properly before the court, but this is an issue that needs to be heard today. We're asking to move forward and I'll let the court kind of decipher what is appropriate and what's not. I just wanted to raise that objection to anything that I was not served with, whatever that is. We ask the court not to consider that.
Okay, let me see. So
Do you want an explanation at all for that?
yeah, I want to turn to you, Mr. Hitchcock. The last thing that I show in my file is looks like I do have the motion to continue that you filed, well, yesterday afternoon. Is that correct?
Yeah, and then you have
Okay.
something I filed last week as well.
I have the filing from August 3rd, the opposition to relocation.
Yep.
Is there anything else that you filed that should be there?
No, no,
Okay.
not at all. And my scanner did, it actually like totally went kaput, and you can actually see it on the scan to Mr. Zandy. But I did forward him all the information that I put in that was at the end, minus the notes. And I said that in the email, and that's actually what it says is the only thing this ends with is the notes that you guys have access to. And then I sent the email of the things that weren't the notes that they did not have access to.
The visitation notes?
Yes, they have access
Okay.
to the visitation notes.
So the text messaging and voicemail and looks like an email that was supplied via email later. Okay. Okay, so it looks like that was I have 43 pages in its entirety, Mr. Zandy, that was filed with the court back on the 3rd of August. I did not, looks like the motion to continue was filed yesterday afternoon. It landed in Odyssey this morning, so I see it's here. I just haven't reviewed it. It's just let me review that real quick here.
And I don't know that we got a motion per se, Judge. What I have is just it looks like a typed out letter from Mr. Hitchcock asking for said continuance. I don't see the motion, but regardless, I think it puts us in the same spot. I don't want to get too lost in the weeds with that, just as long as everybody's on the same page.
Yeah, it just has a cover page on it regarding the motion to relocate.
Okay.
All right, so you're objecting to the continuance. You want to move forward today, Mr. Zandy, and Mr. Hitchcock. Have you contacted any attorneys or tried to contact any attorneys at this point?
I contacted one since they filed this. They haven't called me back. I need to contact them again. And I mean, once again, I mean, this was filed on the 18th for, to move within a month. So I don't feel like that's the right thing to do for my kids. Or, I mean, I also don't believe it's legal based upon the laws.
And if I were to grant a continuance, how much time do you think you would need to be able to be present with an attorney to have the court hear this case?
Well, and it would take like a month, I would think, to get an attorney. Attorneys are super hard to come by these days. And I've interviewed a few in the past, 3-4 months. And obviously I'm gonna have to go with a lawyer that's not superb, but I mean, a lot of them aren't taking cases and whatnot, but yeah, it would take at least a month. And I mean, I also would request that they put forth the 60 days. I believe if it's within 30, it's basically like an emergency thing, like saying the kids aren't safe and my kids are safe.
All right. Thank you, Mr.
Right.
Mr. Hitchcock. Mr. Zandy, go ahead. Yeah.
And here's the quick response to that. This is a case, and again, it's set forth in my client's declaration. It's set forth in the information from the school in which offered her the job opportunity at Southern Utah that states they want to know and they want her there by August 16th. So time is certainly of the essence. This is a case again in which Mr. Hitchcock has done very, very little since last August in getting his mental health evaluation. You're certainly aware after reviewing the pleadings as to what the issues are now with reconnecting families and his visitation being terminated by Miss Fellows. I mean, there's just a litany of problems, and basically my client's life has been on hold, waiting for Mr. Hitchcock to comply and do what the court very specifically told him to do over a year ago. I believe that order was entered on August 2nd, and here we are now on August 8th, and we still don't have any information from the mental health provider. Now, we still don't have any real information as far as the plan moving forward, all because we've been essentially on hold for 12 months while Mr. Hitchcock has dilly-dallied in doing what was required of him, and certainly my client believes that was by design. Things have certainly not gotten any better with him. We have the same concerns today that we had this time last year. And again, there's no assurances of where we're at. My client is essentially, because of that intransigence, held hostage in Cowlitz County when she tells you, I've got a job opportunity, I've got another life to explore, the same one that they had initially discussed upon separating. Now, my client made it well known. The only way really for me to financially thrive would be to go back to Utah, where she has a significant amount of resources, and that's been contemplated from the beginning. So the request to set this over an additional month, again, I don't think is in good faith. If you look back at the prior issues last spring of 2022, you'll see that this again is kind of a common ploy for Mr. Hitchcock. Request a continuance, request another one, not provide the materials timely, not comply with the mental health evaluation that is over 12 months old now. And here we are. My client has an opportunity. She needs to know right away. We filed this motion. We gave him notice within a day or two of my office finding out, within a day or 2 or 3 of my client finding out that she'd been accepted for this opportunity. And again, it's a benefit to her. It's certainly a benefit to the kids. We're asking to move forward today. If we set this out a month, it's a moot point because the job, by all intents and purposes, is probably gone at that point. They'll go with another candidate.
All right. Just give me, I'm reviewing some of the files in Odyssey, and Odyssey froze, of course. So just give me, everybody just hold on 1 second for me. Yeah, my understanding, and Mr. Zandy, if you want to weigh in, it's been a while. It's been a while since I've done a relocation, but my understanding is that a relocation request, if there's an objection, if there's a reason for the court to believe that on a final hearing that it wouldn't be approved, if no notice was given, and I shouldn't say that there was an objection, but if there was no notice, if there was no agreement or notice given, and the court finds that it wouldn't likely be approved upon final order, those are the only grounds, and that it's not in the children's best interest. Those are the grounds for the court to deny a relocation. Are there any, and your client is indicating that there's family located where she would be relocating to. She has a job opportunity there, a home that she'd be able to live in currently that would fit all the children in the home as well. All that's correct, right?
It's correct. And just to take that a step further, the statute gives you 11 factors to consider in a relocation. The presumption is that the primary custodian gets to move, provided there is a benefit to either the relocating party or the children, not both. There only has to be a showing of a benefit to either of those. The 11 competing factors for the court to consider is no more weight is given one more than the other. It's basically just kind of a test and a weighing test of all those 11 factors to see how that pans out. There's the emotional attachment of the children to the non-custodian. There's the likelihood of the non-custodian and his or her ability to move closer to the kids. There's a whole bunch of factors that go into that. Disrupting the primary caretaker's relationship is beyond that of overcoming that as opposed to the non-parental custodian. There's various factors that go into that. And then ultimately the court weighs those against the presumption, which is weighted heavily in the favor of the relocating parent. That as long as there's a benefit to him or her or the children, that relocation is permitted. And then I think you're absolutely right. Court can assess whether the likelihood of the move is more likely than not to be approved at a final hearing, and everything you kind of flows from there. So I think you start with that presumption. You have the 11 weighing factors, and then you have ultimately basically what's the likelihood that at a final hearing or trial this move would be granted.
Ms. Height, you've been involved in this case for quite some time and you are present. Any comments? No obligation, but if there's anything that you wanted to weigh in, I'm happy to hear it.
Thank you, Your Honor. I have been involved. I am, of course, currently discharged from the case, but have been in some contact with the parties since that time. I would tell the court my concerns that were present when I wrote my report now about a year ago remain. I don't believe that they have been mitigated at all. And as far as a move or not move on behalf of the kids, I would say that currently their visits are FaceTime only. And that would not be really impacted heavily or maybe at all, depending on where the kids are residing. So I don't see visitation being impacted at this point.
All right. Thank you, Ms. Height. All right. And just Mr. Hitchcock, and I think you may have cited this, I don't know, in your, because Odyssey is stuck again for me. So I am not on your motion, your objection motion, and you may have cited 2609520. That's the RCW that Mr. Zandy was referring to with the 11 factors. Any additional argument or information you want to give me at this point?
Yeah. Megan has previously, and I've filed this with the court previously, but that she said she wanted to go to Utah to keep me away from the kids. So I argue that it's in bad faith that she's going there. Mr. Zandy argued that she has a job there. That job is $36,000 a year, which is well under what she can make. I mean, she can make that. If I did the math for 40 hours a week. I mean, that's 17 and change an hour. You know, I mean, she could get a job. I mean, any of the multiple jobs that I'm a nurse, but I have multiple friends that are entry-level jobs, and many of them make $25, $30 an hour here. So 36,000 a year isn't really a job to move for. Mr. Zandy stated that he notified me the day after the move. This is the only motion in the past year plus that he has not emailed me. He just sent it. He sent it in the mail the day. Well, he postmarked it on the 18th. That was when the bridge was closed. So I mostly wasn't staying at my primary residence because I was working in Longview. And then I went to Utah for a week. So I came back from Utah. This was just a week ago when I found the mailed motion that was not emailed to me. And there's other things as well. Mr. Zandy talks about the mental health thing. It was always a year wait for the mental health evaluation. The really complicated part is that, like, I asked Mr. Zandy, and you have that, you had the information on that I submitted, but I asked Mr. Zandy if there's any place that I could do it sooner, and he didn't reply to that request. But later I found out.
I'm going to object to anything that's well outside the scope of the declarations, unless this is part of the material that he submitted that I didn't get. But this is all conjecture and well outside the scope.
It's part of what you got yesterday, Mr. Zandy.
All right, go ahead, Mr. Hitchcock.
And I did email and I did ask him if there was any other places that I could get a mental health evaluation earlier. And what's wild is that I just found out in March that there was another person in Vancouver that could have been done earlier. And from my initial, it actually looks like Mr. Zandy has used this person in the past. So the fact that he didn't tell me about him, like, he's blaming me for making this last a long time, but like, he never told me. And I asked multiple people that didn't know about this guy. It's a bottleneck process. And like, if anyone should understand the bottleneck, it's Mr. Zandy, who's a divorce lawyer who works with these people. And I will say as well, like, the visits. As two more things. One, Megan hasn't paid any of the bills on the house. She's been there a year and a half. So she says, "Oh, you can take over the house," but she's leaving me with, like, over like $5,000, $6,000 worth of bills. I mean, she's not just leaving, she's like escaping these bills so she can go live with her parents where there are no bills, and she can, eat their food and have their electricity. And it's not that big of a house. The basement's like less than 1,200 square feet.
Want any response to that?
Are you done, Mr. Hitchcock?
Yes, for now.
Okay,
Thank you.
sure. Thank you. Mr. Zandy, go ahead.
Well, and I was going to argue this from the beginning, Judge. That's where I'll work backwards. I'm going to start with the good. And the good is my client, as Mr. Hitchcock has wanted from day one, has the opportunity to get a job. She's been offered that job at Southern Utah as a tutoring coordinator. That's a good thing. In addition to the pay, and I don't know if the court had the opportunity to look at the benefit package. That benefit package is exceptional. That's retirement, that's medical, that's everything that goes with that. And there's also, again, room for growth and advancement. That's very positive. The other positive of this is my client details for you throughout her declaration. There is extended family in the area. This is extended family that is closely bonded to the children. The children have spent ample time with them at holidays. My client details for you that her parents routinely come up and visit the kids. This is a very strong, well-connected family. This is an area in Utah, and I think it was, I don't want to misquote or misstate that, Cedar Springs, I believe. Cedar City. Nonetheless, this is a place where kids have aunts, uncles, grandparents, cousins, and the like, in which they can, again, pick up right where without missing a beat. And that's certainly a positive thing. This, as my client details for you, was contemplated from the beginning. Doesn't sound like that's been objected to by Mr. Hitchcock. Sounds like he agrees with that. This was never intended to keep the kids from Mr. Hitchcock. I don't know where that comes from. This is where my client's from. They came back up to the Longview area because nurses, which is Mr. Hitchcock, make more money. It sounds like he's agreeing to that. And as he states, yes, cost of living in Utah is significantly lower than it is in Washington State, and $36,000 a year in Utah goes a lot further than it does in Cowlitz County. That's the reality. My client is not a nurse. Again, I would object to whomever it is that's telling Mr. Hitchcock that he or she could make more money. It is what it is. Reality is this is a very good opportunity for not only my client, but the kids alike. Let's look at the benefits to the kids. And again, this is one of the 11 factors that is contemplated in the RCW. If you look presently at the kids' ages, this represents as a very opportune time to transition. And we've got one child who just started at St. Helens and finished the year there. That is Luke. Luke, and my client details personality traits, the things he likes and the things he enjoys. Finished up at St. Helens, and now if the court allows the move, would be going to, and I don't want to butcher the name, Parowan, I believe is the name of this school. We provided you information that shows this is one of the best schools in Utah. This is a school that's recognized nationally, and this is a school that rates out significantly higher than St. Helens Elementary does. My client gives you information about the other two children, about the Head Start plan, about how Maury, who just turned 3 years old, is already doing a lot of these learning type functions and activities, that she was in the Read and Grow program, and that the Head Start program that my client anticipates putting the kids in for some kind of preschool type education and benefit to that as a springboard to school at, again, Parowan, again, is very positive and a good move for these kids. The kids have the ability to be around family who they love and who are bonded to. The kids have the opportunity to have, as Ms. Height stated, the exact same contacts with Mr. Hitchcock that they've had over the past several months, again, due to dad's self-sabotage type methods as it pertains to supervised visitation and not getting mental health evaluations. I think it speaks volumes that he blames me. And again, this is exactly what he's done from the beginning. It's always someone else's fault. I'm lying, the GAL is lying, his past attorneys told him to lie, my client is lying. It's everybody else's fault but his own. To suggest that I should have told him or given him names of institutions in Vancouver seems ridiculous. It also fits this concern that my clients had that was validated through Ms. Fellow's recent visitation notes, that there's this sense of paranoia. How I can advise someone who's not my client where to seek a mental health evaluation seems misplaced at best, if not completely ludicrous. To suggest that he was in this, when he's had two attorneys, and one was, both of them were competent, one was very good, to suggest that he had no idea where to go or what to do, and then somehow blame me or my office, again, is exceptionally misplaced to the point of illogical and lacks complete reason. We are still sitting here 12 months later. Dr. Maherg, who I understand was not contacted until roughly 8 months after the court appointed him, or excuse me, after the court ordered the evaluation. That's concerning. What was Mr. Hitchcock doing in those 8 months outside of making excuses and doing a lot of the same behaviors, if not magnified, that he was doing at the onset of this case? That's a concern. We look now kind of at the negative aspect of this. And again, the file is complete with instances of grave concern. I have not had too many cases in which someone who is ordered to go to professionally supervised visits ends up getting those terminated because of his or her repeated actions, the way that Mr. Hitchcock did. If you look at the information from Ms. Fellows, it's not necessarily his interactions with the kids, although there were some cited in those notes. It's basically this hair trigger explosion and this rage, I believe was the word she used, that is right underlying the surface of Mr. Hitchcock's personality. I think it's interesting that we get those notes, we get that termination from Reconnecting Families. We're in court a couple of weeks later to renew the restraining order. That gets renewed. Mr. Hitchcock again presents in the same type of paranoid manner and placing blame on everyone but himself that he continues to do. Court issues that, orders another protection order and limits contact. And what does he do? Within a day, he sends my client a vague message. And this, again, is beyond me, saying you should take the kids to Utah for a week or two. No further explanation. You could read that one of 100 different ways. To me, that is odd, given the timing and given the history of this case. That certainly can be construed to my client as a veiled threat. There's really no follow-up on that other than, why are you asking me to do that? He says, well, I don't have visits anymore. You might as well do that. The context of that is bizarre. The context of the fact of having the supervised visits at Reconnecting Families pulled and terminated, again, that's bizarre. We're going through this case and he insists on phone calls being recorded. He insists on making threats to visitation staff. He insists on speaking in demeaning terms, all because he's got this conspiracy that I'm lying, that the court is against him, that my client is lying, and everybody's believing these. Meanwhile, we've gone 12 months without any information. Interesting, I sent him an email a month ago, and I provided that to you saying, and it was friendly, it was to the point, it was, have you gotten any ETAs on the evaluation from Dr. Maher? I would like to resolve this case. I know my client would like to resolve this case. And what do I get in response to that? Absolutely nothing. So here we are. And now we get a lot of the same recycled verbiage of it's everybody's fault but my own. My client has a desire to move on. She should have a right to move on. She should be able to move on. And right now, that right and that ability to do that is to move to Utah so she can pursue her own career. The same career she put on hold so that she could follow Mr. Hitchcock to Longview because nurses made more money here than they did in Utah. That's the reality. And in true domestic violence form, he tries to cut that off. He's now using the courts to do that. This is the same individual who filed repeat motions back in the spring that the court denied and told him to quit doing that. This is the same person who's now using the court system as a means to control his wife and control his kids. And this is the same individual who, throughout the course of 12, almost 13 months, has refused to do anything that he's supposed to do that was ordered by the court last year. So again, if you put that in the totality and the context of where we are today, my client should be able to relocate. She has a great opportunity to provide for herself and these kids. The same opportunity Mr. Hitchcock initially complained of is now there. It's enabling my client to make money, to pursue her passion in a field where she is more than equipped to do so. In a field where she has wages, she has income, she has benefits, and she also has the ability under this contract to stay with the kids for at least one full month during the course of the summer. That's in addition to her other days off and the other benefits that she gets under that employment package. That will save on daycare costs. She has the ability to live with her folks for the time being in a spacious, whether it's 1,200 square feet or not, spacious basement in which she can rely on them to help her exchange the kids, to help kind of offset some of the burden that's going to be on her being full-time employed and a full-time mom to 3 active kids, all under the age of 7. She's going to have these benefits of having a piece of bare property, again, which is close to her university, in which she hopefully will be employed at here very soon. She can build upon that. And exactly as he says, it's Utah. So she'll be able to do that for cheaper than she would to build up here based on just the incomes, because there's much more to it than just the income alone. My client tells you she's been a part-time grant writer since she's been up here. She's done that for the YMCA. She's done that for various nonprofits. It never really produced a lot of money. And that was never the intent, because the intent of the parties was Mr. was going to be the breadwinner. She was going to take care of the kids, put her career goals on hold. She's now in a position through this opportunity to pursue those career goals, to do something that's been on hold for several years while she's been married to Mr. Hitchcock and in Cowles County. That's the reality of where we're at. Again, the presumption is very strong. The presumption is that she can move based on a benefit to her or the kids. And Mr. Hitchcock cannot, under these circumstances, overcome one of those 11 factors, let alone the majority of those factors as the law requires, which would enable him to somehow prevent or block this relocation. My client's in that position. This is good for the kids. We're asking you grant that. Secondary to that is this tax issue. Again, this is one where my client details for you, and we've been back and forth again on this for some time. We're asking the court to issue ruling on the income tax filing for the years 2020, 2021, and 2022. The thing that was not contemplated by the court at the time of the original temporary order hearing was the fact that we got some kind of adoption support, which does muddy the waters a little bit. My client has run the figures, and it's essentially a benefit to the community. That's Mr. Hitchcock and my client. If they claim married and file a joint return for those tax years. And again, I think that's a reasonable request. And again, one that I made to Mr. Hitchcock back in March, going so far as to send a proposed order, which we heard crickets. He reaches out and contacts when he wants us, when he wants to be heard. Otherwise, we don't get anything from him. And again, to suggest that I should point him in the direction of a mental health evaluator is borderline ludicrous. That's where we're at. That's the request. It does not impact his visitation with the kids whatsoever. And given that we have literally been spinning our wheels in the hamster cycle for the better part of the last 13 months, it's time to get off that. This is my client's opportunity to do so.
Your Honor,
All right, thank you, Mr. Zandy.
it was a long ordeal. Can I speak?
Briefly.
Yes, I would like to do briefly. My main things is like, once again, like Megan has about $6,000 worth of debt from the house that she's living in that she hasn't paid. My second main thing is that this is not an emergency relocation. This should have been like your typical 60 days out. This is not an emergency. It was sprung very quickly. That's not the way these moves are supposed to work.
Mr. Hitchcock, do you have an appointment with for a mental health evaluation?
Yes, I've done the mental health evaluation. There's been some issues, and that's yes. So it's still getting worked out, but yes.
Okay, so it's done. We just don't have the report back.
Basically, yeah.
Okay.
And I don't know if the report's finished. Yeah, again, this is not how these are supposed to go, is within 60 days as well. I mean, Megan's ducking out of I was paying her Chase account just because it was coming out of my account until I had to close the key bank account down. I didn't know what to do about the mortgage because that was one I just kept paying because you felt like it had to be paid. And she didn't take that over until just April of this last year. So money wise, and then they're asking to have more of my tax return from last year. I don't feel like that's fair. And I don't, again, this move is I want to move in 3 weeks. Let me move in 3 weeks. And once again, that's not the way this works. It's supposed to be 60 days notice. And there's examples of when it's not 60 days, and this does not fall under any of those. And Mr. Zandy tries to make me look pretty bad. And, I don't know how well that works, but it's not, everything he says isn't accurate. Everything I say probably isn't 100% accurate, but I try to be accurate. I want you to know that, and I do speak the truth.
All right. I appreciate that. Thank you. So I think Mr. Zandy addressed in his response the reason for the shorter notice in this case. I understand Mr. Hitchcock's position that didn't provide him a lot of opportunity to respond to the move. And I understand. So I understand both parties' position. We have been kind of in a stalemate for quite some time in this case. I do note that with the most recent restraining order, there is a limitation on, so the visitations are by way of Zoom at this point, or excuse me, FaceTime or some other.
And I have supervised visits, but Beth did cancel those. I immediately found another institution they sent Megan the paperwork, and I asked her multiple times to fill out that paperwork so I could have the visits, and she has not done that. And that's why I said go to Utah. She said why? I said, well, it could be good for a number of reasons, and I would appreciate it if you filled out that paperwork. I don't know if you had the chance to review my what the kids what the notes, the visit notes said, but my kids and I relationship is pretty amazing and wonderful, and they continuously asked to come to my house to if I can come over. These things where they're being denied access to me, and again, I argue this is in bad faith. And I can get you even today that information where it says that Megan was trying to keep them away from me. You know,
Well, I appreciate all that, Mr. Hitchcock, and I do note that a lot of these visitation notes are very good. I'm not sitting here in judgment of you as a person or you as a father. I do understand some of the concerns that the other side has brought up. Frankly, this case isn't over. So to think that Ms. Hitchcock is the sole decision maker on your access to the children is incorrect. So because that hasn't been ultimately decided yet. Before me today, so and I did also note in your objection to relocation, you touched base on the taxes and your concerns with that.
yeah, again, the 6,000, like
I let you talk without interrupting you, Mr. Hitchcock, so I appreciate the same.
Right.
So assuming the numbers are correct and it would be a benefit to all the parties to file jointly for 2020, 2021, and 2022, I'll authorize that. I will, I'm going to authorize the move, but I also, on a temporary basis. So I think it needs to be some additional information exchanged. I also, at this point, with visitations via FaceTime or whatever, those shall continue with Mr. Hitchcock. Additionally,
I have a couple of requests.
There's a request for, I know that Mr. Hitchcock indicated that he requested that visitations be set up through the agency in Vancouver. That hasn't been done. With the start date of this new position a little over a week away, I'm assuming that won't happen before. However, what I would like to, I'd like to have, if at all possible, the children have an opportunity to have a supervised visit with dad before they leave. And if the agency in Vancouver is where it needs to be, then I'm assuming Mr. Hitchcock will try to get that set up and work with Mr. Zandy to get that set up. The kids should be able to see dad before they leave. And I know that's a quick turnaround time, but frankly, the ask came in a kind of an expedited manner. And so I'm going to order that occur. If there is some, I guess, Mr. Zandy, I want that to happen no matter what. And if that means there's a request that somebody else supervise that both parties agree on for a last visit, that, you know, that I want a visit to happen. And then he still has, there's nothing that stops supervised visitation moving forward. So if he requests that, then
I do request that. There is one in Cedar City I've looked up.
so if he comes to Utah and wants to visit the kids, then she has to help facilitate and make that happen. Right.
Essentially keep the orders as is.
Yes.
Correct. And then just make sure that we get between now and the 15th, some kind of we'll work hard to try to accommodate that too.
She said, do it no matter what, Mr. Zandy.
Like I just said, work very hard to accommodate that as well.
All right. And as far as the money and the house and the transfer of the house, I don't know, Mr. Zandy, there's obviously Mr. Hitchcock has concerns about some outstanding debt on the house. I don't know if, and that wasn't addressed in your response, probably given his late objection. I don't know if you want to set this for a review in a couple weeks to discuss that matter, or
I'd rather not. I'm hopeful that a couple of ways. If he wants to have the house effective after my client moves out, which would be on the 16th, that's fine. My suggestion would be we reserve any issues related to that. My client does have a response to that. I don't think what you been provided necessarily accurately reflects what's truly happened in this. Nonetheless, we should reserve that, put it on a balance sheet when this case is all over and resolved. In the meantime, he can make the payments on the mortgage moving forward, and we can go from there. If either wants to bring it back, if I'm incorrect, then certainly they can do that. But for now, with as many times as we've been in court over the past year and a half, I just assume try to keep the costs and the appearances down as much as possible.
All right.
I would ask that she pay that before she goes, the taxes.
Well, my hope is that since she's been living there, she's been making the payments without any additional information before me. I'm not, all you did is say that she hasn't paid. I don't have anything that shows me.
It's in there. I attached it. There's like 5,500 due just in taxes. It's
The existing order states she's to pay the mortgage and that he's to pay the taxes, and the insurance is the best of my recollection. Again, I can confirm that, but she's been paying the mortgage.
I know exactly what the order
That's an
says.
issue
And
that
it's
we're
not
probably
that.
gonna have to circle back to on a balance sheet when this is all said and done.
Your Honor, the order doesn't say that. I can tell you exactly what it says if you'd like.
Which order are we operating under?
He's talking about a previous order that I was.
I understand that. When was it entered?
Oh,
January 4th, 2022, I believe.
I was to pay the mortgage through June, mortgage and taxes through June. I ended up having to pay the mortgage through March of this year, April of this year.
January 4th, 2022?
I believe so. I believe it was the initial order from
It was
temporary order
2021.
Back when Mr. Hitchcock was represented by Miss Baldwin. I believe Judge Hahn entered that order back then.
20 of 21. 2021. Sorry. 21st.
Maybe it does make sense that we just reserve on that so my client can respond. And I would suggest we set this out 3 weeks for presentation. And if there's any issues on the house, we can take it up then.
Your Honor, if she leaves, she's never going to pay it.
January 18th, 2022 from the hearing on the 4th.
Yes, I see it. I am looking at it now. So the mortgage is petitioner. And petitioner pay home mortgage through June 2022. Thereafter, respondent pay home mortgage is what this order indicates.
And it was clarified in July of that year. And but I mean, once again, it was just through June. And once again, I ended up paying the mortgage through April of this year.
Okay. Well, let's so if we are setting presentation for the 29th, let's review the issue of any outstanding payments or debt on the home on the 29th, 1 o'clock.
Fair enough.
So
In the meantime,
meantime, everything other than the move is approved, everything else is status quo. And either party, if you want to file supplemental information regarding any debt on the home, taxes due, feel free to do so.
thank
Your
you.
Honor, one more question.
Sure.
Megan has lived in the house. We've been separated almost 3 years. She's had primary use of the house that time. If, you know, I take it over, then I like, whatever, if I fix it up, I mean, I would ask that the order would be that I would get to live in it for a year, that I would get to utilize it for a year. Just because, you know, Mr. Zanny could come along in 2 months and try to force the sale of the house. If she's giving me the house to take over, I would ask to have it for 6, 8, 10, 12 months so that I can actually have the house, not just fix it and have it get sold. Which obviously we're going to sell it, or I buy her out, but I would ask for some time with that.
Okay, if that's your request, then make sure that you remind me of that when we are discussing it on the 29th. All right.
Yeah.
All right. Thank you. Good luck. See you in 3 weeks. All right. Hitchcock and Hitchcock, 213-0035-808.
Matter's ready.
I have a presentation of order. Order on hearing from the August 8th, 2020. It says 2022 hearing. Is that supposed to be 2023?
Yeah.
It was clerical error. I apologize.
All right. And Mr. Hitchcock, did you receive a copy of that proposed order?
Yeah. And if you remind you, 5 weeks ago, I asked that I get a time to stay in the house. Summer is the best time to sell, so I wanted to stay just through June, just to have that on the books in an actual order. That added, as well as I'm not getting to see my kids as often. I'd like to ask for 2 FaceTimes a week.
Let's see here. It doesn't show that there's a limitation on the FaceTime. Was that I don't see that there was a limitation, so I don't have a problem with 2 FaceTimes
If
a
we
week.
can put that in the order, that'd be great.
But I think what we did was we just adopted anything that was not inconsistent with the hearing last month. We reserved and kept that pursuant to the existing parenting plan that was entered last August, I believe. So I'm not sure what that is. Again, that wasn't ordered by the court. I don't have consent one way or the other from my client related to that request. So I can't really offer much assistance on that issue. I just asked that the order be, I'll talk to my client obviously, but I think the order should just remain as crafted.
Your Honor, she's moved over 1,000 miles away. I mean, I have greatly limited options to see my kids.
No, I understand the request. It does appear that initially it was 2 FaceTimes a week in the parenting plan, and that looks like Judge Hahn changed it to 1 based on the temporary, because of the temporary restraining order.
It was initially
I don't need any additional comments. I'm okay. Thank you.
I was just
So
explaining.
I'm gonna indicate on here FaceTime. Will be limited to 2 calls a week. Okay, so that means you can have 2, you can have 1, you can have 2. All right. If they agree to additional, then that's between you, but you get at least 2 as far as I'm concerned.
Thank you.
And there is no, when I'm reading this document, Mr. Hitchcock, there's no indication that says that there's a time frame for you to have to sell the house or anything like that. It's just that you're responsible for basically the mortgage, taxes, insurance, and utilities moving forward.
And again, there's $5,500 in unpaid taxes. As well, there's unpaid utility bills that I'm gonna have to catch up. I'm gonna have to pay and then pay to hook up, which is not fair.
I thought at the last hearing, we determined there was not, there
No.
was not any back mortgage due.
There was back taxes, $5,500.
Okay. Well, that issue can be reserved for trial. Is that was part of the respondent's obligations that weren't paid, that can be reserved for trial. So I'll sign off on that order. And then I show that we're just on for review hearing and a presentation of order. So I don't know
Yeah, I was gonna.
what else we were reviewing today.
That's it. I also wanted to talk about, just ask for a bifurcated divorce. This has been really tumultuous for both parties. It's been 3 years since we've kissed. I did put forth the motion, but it didn't get added. I just threw it in this morning to see if we could do it. But I am asking, Megan's moved out of state. I want to move on with my life. I'm religious. I'm not dating seriously. I've talked to girls, but most of the girls that I want to talk to, won't talk to a married person, which I technically am. And I do want to have a bifurcated divorce.
I did see, did you file an order along those lines, Mr. Hitchcock, recently?
I did just today. And I mean, we can come back in a couple of weeks, but it's going to cost more money for Megan. And obviously, I mean, I work Tuesdays, so it's going to cost money for me. But I did put a motion, if you are willing to, an order, if you're willing to sign that, to free me to move on with my life.
Did you provide notice to Mr. Zandy?
Absolutely. I dropped off that in his office.
Mr. Zandy, did you receive that?
I did, and I've got concerns. It wasn't a motion. It was a proposed order in addition to an affidavit that essentially says he wants to date Christian women. None will date him because he's still technically married. So I don't think that from a procedural or statutory standpoint, that's appropriate or complies with that. To bifurcate means you do part of the divorce in one section, you reserve on the other part of the divorce for another section. Typically, we see that with assets and debts, and then maybe and support issues, and then maybe a parenting plan. We don't have any of that right now. This is the case where we're still awaiting, and it's been well over a year, the results of the mental health evaluation that we don't have. There's still issues, as you just entertained, about the home, and the assets and the debts with that. So there's really nothing to bifurcate other than signing an order. And if I'm reading that correctly, and again, I just got it this morning, enabling Mr. Hitchcock to go out and date Christian girls as he wants to. I don't think that complies with the statute. I'm not opposed to bifurcating. I just don't know where it gets us. And the request is made, doesn't have a motion, and it doesn't comply with any statute that I'm aware of. So I guess that's my input on that. I don't think it's appropriate at this time.
Your Honor, I don't know why Chad would be arguing against this. It lets his client, she as well, is not dating. It lets her move forward.
Okay, well, here's where we're at. I saw that something came across. It's not an odyssey. I don't have something in the file requesting that. At this point, if there's an agreement and you can work something out with Mr. Zandy, I know that, are you still working on getting an attorney?
I am. It's not working out very well just because everyone's booked up. Your Honor, it's not fair that I should be held hostage in this relationship.
I guess I'm not holding anyone hostage in any
No, and I'm not saying
relationship.
you are.
But I also can't handle motions that aren't noted before me on the docket.
Yeah.
So
I was just trying to save time. I will file a motion and we'll come back.
If Mr. Zandy's willing to agree to, if you want to talk to him about it and he's willing to agree, then I'm happy to sign off on that. And we can go that route. Otherwise, I think you'd need to note it on the docket and make sure that any additional information is filed and provided to Mr. Zandy.
I will put forth the motion.
All right. Thank you, Mr. Hitchcock.
Okay, let's take up the Hitchcock matter. I see a couple pleadings in the file, and there's a motion for reconsideration that Judge Fassett needs to address, and those motions I generally are just determined on pleadings alone. So, and then I see a motion to bifurcate the proceeding. Is there anything else I need to address today?
That's it.
I think that's it, Judge.
Okay. So, Mr. Hitchcock, this is your motion. Go ahead. If there's anything you want to say besides what you submitted.
Just that this relationship has grown toxic, unfortunately, and it continues to do that, become more toxic and more bitter. And a bifurcation would be in the best interest of both parties for their mental health. You know, there's a number of things that we won't get into now, but like there's just incredible bitterness from, you know, and hurt on both sides. And Megan's continued to do things and that have hurt me, and I can do, you know, she's been hurt, and it would be very good for me to have this marriage legally ended. We've been separated for over 3 years, you know, and every step has been a fight. I don't know why this step has been a fight. I'm just asking that we legally dissolve the marriage, as this will, I mean, going to trial will take another year from what I understand. And there's animosity being attached to this woman who continues to do things that hurt me, and she feels hurt. She recently, a few months ago, from our old church over the pulpit, said that she was in an abusive relationship, meaning with me, but we haven't.
Your Honor, to object to anything that's not before the court.
Yeah, no, this has been reported to me, and I mean, we're not in a relationship. The fact that she uses me to say she's in an abusive relationship, I've never been abusive to her, and I want to bifurcate this divorce. I want it to be legally ended, and I don't understand. I really believe the opposing party lawyer is drumming up business for himself. I mean, Megan's got to he's spending over $600 for this, you know, for no real reason. How does she have it both ways? She hates me and I'm so horrible, and she doesn't want to bifurcate the divorce.
All right. Thank you. Mr. Zandy, any response?
Yeah, I guess I'll start with the obvious. As far as drumming up business, that's the last thing I need to do. I think the family law attorneys in the local area are beyond overworked, and there's a lot of business to go about. And certainly this case is not necessarily one that has a gold mine at the end of it. We're doing this because unfortunately we're here on, again, actions of Mr. Hitchcock, which continue to abuse the court system. And we're here on a motion to bifurcate, and there's no legal or factual basis to do that. I would certainly wager to say that anybody going through a dissolution action would love to bifurcate their divorce and just simply be resolved after 90 days, but that's not the reality, and that's not what the law sets forth. Now, we have given you the basis for bifurcating cases and divorces, which states it's generally, and that's the little case, that it's generally disfavored, absent some agreement and factors which would warrant said request. That's done when there is a certain agreements on material aspects of the case and not on others. That certainly doesn't qualify here. This is one where Your Honor has not heard the majority of the motions that have been brought by Mr. Hitchcock, but he was warned last spring after he filed a motion to compel without requesting discovery or conducting a CR 26I conference. He has later filed motions to set aside restraining orders. He has generally lacked and then grasped understanding of how this process works, but unfortunately that has not stopped him from filing frivolous motions. And this is, again, just the latest
objection. It was never said that those were frivolous motions.
The argument is this one is. The argument would be that this needs to fall under that category because, again, pursuant to that, there is no legal basis and there's no factual basis. If the court was to grant his order, which essentially says the case is bifurcated, the parties are divorced. There's implications on that for taxes, property, debt, parenting plans. There's insurance inquiries that go into that. And if the court just says, okay, you're divorced without a decree doing that and finding the marriage irretrievably broken, that would be in significant error and would potentially jeopardize both sides' rights under insurance, taxes, and the like. In my review of Mr. Hitchcock's declaration, it looks like the sole reason he wants to bifurcate the case is so that he can date, quote, Christian women. Again, that hasn't stopped him in the past. We've provided you information from some of his pursuits in which we have no idea who they are, but they reach out and send my client random notes that say, hey, I'm glad there's a restraining order. This guy is outside of his essential mind. And again,
Objection, that's not what was said.
Completely random. That was spontaneous and sent to my client. We filed that previously. And again, I'm paraphrasing, but that was the gist of it. And to suggest that I want to be legally divorced for no other reason so I can date other women is unfounded and it's not supported by law.
Objection, that's
But
the
also
12th thing I
say,
said.
All right. Mr. Hitchcock, I understand you may not agree with this. I'm going to hear the argument.
And I'm just saying that I object that he said that the main reason I wanted was to.
Objections noted. And go ahead, Mr. Zandy. Anything else?
yeah, so if you look at the basis again for a bifurcation motion, this doesn't quantify or qualify under that. And this is an individual who unfortunately has been sitting here patiently for 15 months, who was ordered to undergo a mental health evaluation, and we still have nothing related to that. I've sent requests, I've provided those to you as part of my exhibits to my client's declaration, which show, despite multiple requests, multiple inquiries from the court, we have nothing related to his mental health evaluation that was ordered nearly 15 months ago. That's unfortunately been the hang up on this, to grant a motion to divorce these people when there's material issues that still have to be resolved, which are directly impacted by that order, just for the sole purpose of Mr. Hitchcock going out on and pursuing his Tinder dates or whatever it is he plans on doing, again, is
Objection.
In error would be in error. So that's my argument. We are asking that you find a CR 11 sanction. Again, it seems extremely frivolous. My client has paid money, and again, unfortunately, her fees are the direct result of Mr. Hitchcock continuing to file motions such as these. So we do believe that a strong message should be sent. And I think the only way to do that is through financial recourse. The court has imposed, by my count, up to about $3,500 in total fees that he was ordered to pay in the past. And to date, he just hasn't done it. We're also asking that you set a date certain for him to pay his fees, and also require an order that says the court should review and approve any proposed motion that he wishes to file. We now have this motion, which is pending, and we have a motion to reconsider, which is pending, which is ironically related to tax issues, which are directly impacted by a bifurcation motion. So again, if you look at it logistically, it makes zero sense, and it's due by design of Mr. Hitchcock, and it's abusive litigation. I mean, that's the only way you can really detail that, and it absolutely needs to stop. And we're asking the court to again enforce its prior ruling from the spring, in which it said this isn't going to be tolerated any further.
Your Honor, I don't believe most of what Mr. Zandy is stating. So he's arguing that Megan wants to stay married, so we file taxes together. That's not a reason to stay married. That's not a reason to put us through the mental anguish of being legally connected to someone who hates, maligns, badmouths. Once again, I mean, we're talking so. And Washington does allow bifurcation. All the states do. Washington doesn't as much, but it does allow bifurcation. This isn't a frivolous motion. This is a legal motion that I've set forth. And I'm surprised that they brought it to court. I thought it was going to be signed. Once again, I think the main thing that Mr. Zandy is saying is that there's potential money things. Like, even if we weren't married, if we had never been married,
there still would be the same laws in place. I'm not asking for anything other than to be divorced, because it's bad for my mental health and I don't believe it's good for Megan's. Once again, she's saying like, oh, I'm in this horrible marriage. Like, you're not in a marriage. We've been separated for 3 years. And I find the Tinder date thing offensive. And once again, he said that it's been argued that the main reason is to date other people, but that's the 12th thing I've listed on a list. I mean, Megan has a 6-page declaration and I have 13 bullet points. I'm just asking to be divorced from this woman. That's it.
All right. Bifurcation is not a process or a procedure that's favored in Washington.
It is under toxic situations, though.
Hey, wait a minute. You're done talking. I gave you plenty of chance to talk already. So at this point, bifurcation is not favored in Washington. I don't see a benefit. And it has a lot of potential consequences that Mr. Hitchcock, I think, frankly, you just probably don't appreciate. And if you're representing yourself, you end up being held to the same standard as an attorney, which admittedly is a tough thing, I think, sometimes for pro se litigants, but there has been in review of the file, just a number of motions that seem to be without basis. This is a motion that I don't see as having really any basis, legally or factually. I am going to impose $500 in legal fees payable to the office of Chad Zandy. Those fees need to be paid by December 1st. In terms of any order regarding Mr. Hitchcock and filing motions, I guess, is that just a request you're making here? Because I didn't see that in your pleadings.
No, I think if you look at the last page of my client's declaration, it was there. That's on page 5, line 13 through 15. I would also ask the court to require Mr. Hitchcock to have any motions filed on his behalf reviewed and approved by the court prior to filing and serving those. And then my client details the significant resources she spent responding to motions such as this. And it's gotten really bad since late last winter, and now obviously here we are on another kick of bifurcation motions and motions to reconsider and such that, frankly, my opinion, I don't see a lot of legal merit to. And I just want to avoid that if we can. And I think this is the only way to curb that. I realize that it's kind of an extreme measure, but I think we've broached that point. I think that's really the only way to curtail some of the abuses.
I'm looking at the declaration that was filed October 2nd.
That's the motion to reconsider, Judge. This one was filed on September 22nd. So the one you're referencing on October 2nd was filed in for the motion to reconsider, which should be in front of Judge Bassett. he's asking the court to reconsider her decision from
Okay,
a month and a half ago or so.
That's legal.
I'm going to enter a separate order that does require the court to approve.
Your Honor, can I speak?
No, not until I'm done with this. All right. Any motion that Mr. Hitchcock wants to file needs to be sent to Superior Court admin at Cowlitz.gov, excuse me. And I'm going to need to revise this, but so I'm going to rewrite this, but the court will review the pleading and determine that it's not frivolous prior to the document being filed and served. So Mr. Hitchcock, what that means is you're going to need to email anything you want to file with the court to that email address. A judge will review it and determine whether it's appropriate to move forward, whether there's a colorable argument or a valid argument that's being made. And in these situations, the court will probably err on the side of allowing you to file the document, but there needs to be, at this point, there's been enough what appears to me to be frivolous litigation that the court needs to, and fees, the imposition of a number of fees have done nothing to change that. So this is an extreme remedy, but I think in this situation it is justified. I'm going to enter an order that's substantively what I just announced. I just need to rewrite it and give it a little more thought before I actually finalize it. That should be an odyssey within the next day.
And you said I could speak, but I did talk to Judge Fassett about this in Megan's previous motion, and it was said that I would have to bring it forth in an actual motion, which I did, which is what she said I would have to do.
Okay. And I don't think this is inconsistent with that. I'm just taking it an extra step now that I've reviewed the motion that you filed. She didn't have the motion in front of her, but now that I've reviewed it and reviewed the response, I think this is appropriate given the overall context of the case. So that'll be the order of the. So I'm going to be entering two orders. One order that imposes $500 in legal fees to the office of Mr. Zandy, payable by 12/1/23, and the other order requiring you to file any pleadings or have any pleadings reviewed by sending them by email to the court before they're filed.
In the first order, Judge, I'm assuming specifying that the order to bifurcate is denied and is frivolous? Yes. Okay.
It starts out, Mr. Hitchcock's motion for bifurcation is denied.
Okay, thank you. And I don't know if we were going to hear from Ms. Height or not. Somebody asked something, maybe that was on Mr. Hitchcock's end.
No.
Ms. Height, do you have any information you thought was germane to this?
I do not, Your Honor. Thank you.
All right, thank you.
Thank you.
I believe that concludes the docket.
All right, Hitchcock and Hitchcock 21-300-35808.
Matter's ready.
All right, this is on for a motion to provide mental health evaluation report and findings.
Correct. And this is on my points.
And is Mr. Hitchcock present?
Yes, ma'am.
All right, thank you. Good afternoon. All right. I have reviewed the motion. I've looked back at the previous orders that were entered. It wasn't myself. I think it was another judge that initially ordered the evaluation. I did receive from Mr. Hitchcock response to the request and his concerns about Dr. Maharg's report. Any argument, Mr. Zandy?
No, I think the motion largely speaks for itself. My client just wants access to that. This case has been on the better part of hold for the past 16 months, pending that evaluation coming back. From what I understand, the evaluation has been done for several months now and has not been released due to Mr. Hitchcock pulling his waiver to Dr. Maharg. In my communications or attempted communications, it was made clear that the office would prefer a court order in addition to the one that they already have to clear any potential hurdles. We did file a subpoena. We did issue that to Northwest Psychological Services. It's there. And from what I understand, Mr. Hitchcock just unilaterally decided he didn't like said report and that it was biased, which again is unfortunately kind of typical at this point, and instructed the office not to submit that, contrary to the August 2022 court order. Simply asking that that be produced, simply asking that the order reflect and direct Northwest Psychological Services to issue that directly to me pursuant to the terms of the existing order. And again, consider some kind of attorney's fees and costs. My client has outlined for you some of the frustrations and some of the expense she's gone through over the past year and a half or so, due largely to Mr. Hitchcock's antics. I think it's interesting that he refuses to give the report, but then cherry picks and quotes certain provisions in that report as part of his response for today's hearing. So again, kind of is what it is. I think just getting those results pursuant to Judge Hahn's order from last year is certainly kind of the center pin as to where we're at with this, and we need that prior to setting any trial dates or mediation dates or such, but that's certainly information the court has contemplated and been patiently waiting for the better part of 16 months. We're just simply asking that we enter some kind of an order that directs Mr. Hitchcock to, number one, cooperate, and number two, Dr. Maharg to issue those directly to us.
All right, thank you. Mr. Hitchcock, any response?
Yes. Yeah, I mean, I clearly showed me, Dr. Maharg said that I was fired when I resigned. And then he went on to say that I worked for multiple pediatric home health agencies when I've only worked for one. And that was just from his intake with me. The report can be released, but like, again, like, I mean, it is clearly biased. I mean, like, it's not accurate. I mean, just the fact that he's saying that I worked for multiple companies when I worked for one, and I included that statement from the family that I work with. And that was just one thing I picked. I mean, there was a number of things that were just clearly erroneous with it. So if you want to release it, that's fine. But again, I am concerned about its accuracy because he said things that weren't accurate. Yeah, and Megan's always asking for money. I don't have any money. If you remember, before she moved to Utah, she said she had property there. Megan has already purchased property. She's left with $6,000 and around $6,000. And
Judge, I would just object to anything that's far outside the scope of the content of the motion today. I think we're getting way far afield of that.
You're asking for money, Chad, and I don't have money to give you. I have no money to give you.
All right, it sounds like, okay. If you disagree with the contents of the report, that's perfectly fine. That's the contents of the report aren't necessarily going to be accepted as, by the court as this is, the truth of everything. That's something that can be brought up at trial. That's something that you can question Dr. Maharg about. But it sounds like you agree that that report should be released. I don't see a proposed order, Mr. Zandy. I mean, I can write a bench order up after court, or if you want to draft something and send it and I can sign it.
I think given the history of this case and the allegations that are constantly raised in some of and again, to use prior judges' term, frivolous motions and such that have been brought by Mr. Hitchcock, it's best just to preserve the record. So I think if we have a presentation date for 2 weeks out, at at which time we can appear, you can sign it, and we can hopefully move on. I think that's probably the most prudent way to go.
All right. Does the 12th of December work for the parties? I'm
That's
open any of the December dates. Mr. Hitchcock, are you available the 12th at 1 p.m.?
Yes, and I would ask while we're here, my ex and Megan and Mr. Zandy's office have made it very difficult to do visits in Utah. I'm traveling over 1,000 miles. I've had to take additional time off work because they said I can't do 2 visits in 1 week. Every 2 weeks. Can you speak to that at all?
And again, I would object to anything that's outside the scope of the motion in front of you today.
Your Honor.
If there's a concern with your visitation and how that's happening, if you want to file something and we can hear that on the 12th potentially as well, we can do that. But what's before the court today and the information that I have before me today is in regards to the evaluation from Dr. Mahard.
Okay.
So we'll set it over to the 12th of December for presentation at 1:00 p.m.
And fees, do you want to reserve those or do you want to issue any specific amount?
I'm going to reserve on fees.
Okay.
So
And you want me to include that both parties cooperate to get those published as soon as possible pursuant to the order?
Yes,
Okay,
please.
very well.
And
Thank you.
reserving on fees, Mr. Hitchcock, means if there's something that you wanted to present to the court specifically regarding fees, you have an opportunity to do that before the 12th. Right? I have Hitchcock and Hitchcock 21-300-35808 for a presentation. A few presentations. I'm going to try to work through those. Now I just have to find it again. Actually, I reviewed it in Odyssey. Did you send over a hard copy?
We did on, it looks like November 30th. I can send over another one if you need me to.
Okay. Well, I reviewed the proposed order in Odyssey. It appears to be appropriate. There were no objections filed. And frankly, nothing has been filed post our last hearing apart from the response from the Court of Appeals. So I will sign that order. I don't know, Madam Clerk, is that a order that you may still have with you?
No, I do not have any orders left.
Wait, it was stuck to the back of one. I have it. Yay. Okay. So Mr. Zandy, I have that order. I'm going to sign it and I'll get it filed after court.
There's only one thing I did want to make you aware of, Judge. The one thing that I included that was not specifically ordered was the date by which that report shall be provided. I plugged in December 8th. We don't have it. I did receive an email from Mr. Hitchcock saying he's apparently tried to communicate with Dr. Maherg and is having some issues with that. I am fine if you want to kick that December 8th back a week or so to the 15th. That would give him additional time. He didn't specifically request that, but again, given the tenor of this case, I have no issues if we make his life a little bit easier, if that's what it takes to get this report. It's done. It's sitting there. We just need him, Mr. Hitchcock, to sign the release of information so we can get it.
I changed that to December 15th by close of business.
Very well. Thank you.
Which shows as 3 p.m. All right. Thank you.
Yep. Thank you.
Anderson and Erickson, 21-500-07308. And then 23-300-01508. And Miss
Your
Winkle,
Honor, I was just going to say, do you mind if I turn off? I broke my jaw, so do you mind if I turn off my camera so that it's not like not seeing myself?
That's fine. That's fine.
Thank you.
Oh. Sorry. Mr. Zandy, hold on, Miss Winkles. I'm just gonna, Mr. Zandy, it looks like Mr. Hitchcock is present. So and he's now connected to audio. So Mr. Hitchcock?
Yeah.
Hi, we just called your case. I didn't see you here, but I see you here now. There was an order that was presented by Mr. Zandy. Basically saying that you need to turn over the report.
Yeah,
So it basically says what I ordered at the last hearing, but instead of the report being due last Friday, we're having it due this Friday. So because it sounded like you were having Mr. Zandy indicated that you were having a few difficulties with that. So I didn't want to enter an order that wouldn't work. So any questions about that?
I did email Dr. Maharg Thursday and Friday. He didn't get back to me. I believe that did Mr. Zandy have a subpoena that he submitted to the court?
I don't recall any subpoena. I mean, I know that there was.
No, we wouldn't have subpoenaed the court for anything. We subpoenaed Dr. Maherg to get said report, at which time Dr. Maherg indicated that he would prefer to have a court order, given some of his issues with Mr. Hitchcock signing release of information. So that prompted the motion. So we now have a subpoena that's outstanding, as well as the order which Dr. Maherg preferred. So.
Yeah, he wanted a subpoena that was signed by the judge, so we could have the judge sign it to release the records to Ann Hite and Mr. Zandy. That would be, I think, advantageous. I mean, if I can only email him so many times.
Because all he has to do, Judge, is my understanding, is go to Northwest Psychological, say, I'm going to pull my restriction on the release of information and go ahead and release that. He doesn't need to talk to Dr. Maherg about that. He just has to go over there and do that with Northwest Psych. So again, this is kind of the gamesmanship that we've been unfortunately subjected to over the last 17 months, patiently waiting for this published time and time again. So that's all he's got to do.
So the order, Mr. Hitchcock basically says that that it needs to be provided to the court. That should be more than sufficient for Dr. Maharg to turn over the report. Additionally, at the last hearing, there was an indication that you essentially revoked the ROI. And that's part of why Dr. Maharg didn't want to release the information, because he didn't have your permission to do so. And that's why he wanted an order. So we now have an order. I've signed that order. You can get a copy of it from the clerk and you can take it over there, or you can just pull your, the hold on your ROI and have that information either provided to you and you can provide it to the parties that need it, or ensure that it gets sent to Mr. Zandy and is it who's the GAO? This Hite. Okay.
Yeah, can you include that in the order to release it to Ann Hite as well as Mr. Zandy?
It's already in there. Immediately made available, provided to the court, which you can file that and to my office. So I can certainly forward that to Miss Hite, or she can pull it off Odyssey on the computer, but she'll certainly get a copy of that.
But it doesn't say to Ann Hite. So if it says to Ann Hite,
she can get it from the court. Okay. Okay, I've signed that order, so you're up to date. You'll be able to pick that up, I would think, tomorrow, Mr. Hitchcock, if you need it to work with Dr. Maharg's office.
All right, thank you.
All right.
The next hearing in the case was on April 3rd, 2024, on the trial assignment docket, where they were scheduled for a mandatory settlement conference. That MSC took place on July 8th, where, to no one's surprise, they were unable to come to an agreement.
Number 3 on the docket, 21-3-00358-08, Hitchcock and Hitchcock.
Matter's ready, Judge.
Just a second here. Do we have anyone else present other than Mr. Zandy? Do we have Mark Hitchcock present? Mark Hitchcock. Looked in the waiting room, not there. So with that, Mr. Zandy, any information at this point?
No, and it's somewhat unusual, Judge. He's usually very active in these proceedings. This case was filed back in the middle of June, I believe, on the 19th or so. We did give him email service, as well as mailed it to his last known address in Rainier, which is the home of, I believe, of his mother. Yeah, we did have a settlement conference last week in front of Commissioner Carmi, who was aware of the hearing. Mr. Hitchcock was aware of the hearing. So the fact he's not here today is somewhat surprising, considering his past involvement has been extreme, to say the least. I do think the request is made in our motion is appropriate. From the information that has been provided, I think the parties do agree that the house is listed for sale with Debbie Troll. I think we're still asking for that. As far as what we do with the net proceeds, I'm just asking that those either be placed in my trust account or in an interest rearing account someplace else. I don't really care. I just want those funds to be preserved as much as possible. And that initially out of the sale proceeds that Mr. Hitchcock get current on what by my count, there's about 5 or 6 different judgments out there for attorney's fees and sanctions and costs. And there's also $1,000 that's owed to Dr. Maherg for the mental health evaluation. We would ask that upon the sale, by my math, that's about $4,100. I can certainly rein that in down to a dollar amount if necessary. But we ask that anything that's owed by Mr. Hitchcock be paid from his portion of those sales off the top.
Well, he was aware of today's hearing, was served and given notice as far as the date and time of the hearing. So with that, I did review the files and record, and based on that, number one, the home will be listed for sale through Debbie Troll. I'm not quite sure how to say her name. I believe that's at TRULL. Any disputes of a material issue can be resolved by the listing agent, such as price, showing, staging. Repairs and maintenance are not as, I would say, that are $500 and less. She can agree on. Anything more than that, the court would want it to come back before the court. Contract terms and other necessary aspects of the home sale can be resolved by Ms. Troll. The only concern I had was on repairs and maintenance. So I didn't want to see a really large amount come up and that be an issue. And then the proceeds shall be placed in the trust account, Chad Zandy, with ordered and approved distribution of any attorney's fees payable to Mr. Zandy by the husband's outstanding guardian item fees, and the husband's outstanding fees to Dr. Maherg, all to be accounted for under husband's share of final distribution of funds.
Very well. And I'll have an order coming over ex parte, hopefully by the end of the day or tomorrow morning.
Okay, just make sure to note on there that he was not present.
I will do that. Thank you, Your Honor.
Thank you.
130035808 Hitchcock v. Hitchcock. I believe I have Mr. Zandy present. And who do I have for petitioner, if anyone?
Miss Rush, Your Honor, but she's got a memorial service today, so I'm handling this for both of us.
Oh, gosh. Okay. Sounds good. And I see Ms. Height there. Good morning. And I know
Your Honor.
this can't be in front of myself or Judge Evans, and I have noting set for 1 day non-jury.
I think it's going to be more than 1 day. I think this is at least 2. And Miss Rush indicates that she doesn't have any availabilities until the fall. So let's keep it at 2 days for now. And then if we have a civil priority week, which I doubt, in October, I think that's as earliest as Miss Rush says she's available.
We can do the week of October 6th, 2025.
That's fine by me.
And then readiness would be September 30th, 2025 at 11:30.
Okay.
Very well, thank you.
Thank you.
Thank you.
They have a 2-day trial set for September 30th, 2025 to finalize their divorce since they were unable to come to an agreement at the MSC. This case was relatively quiet in 2024, with only one hearing noted up by Attorney Zandy. My assumption is that the only reason it's been so quiet is because Mr. Hitchcock is forbidden from filing any new motions without prior approval by the court. It's no surprise to me that this case will be going to trial, as Mr. Hitchcock seems more interested in getting his own way than he does wanting to have his divorce finalized. He really is his own worst enemy. Thank you for watching. See you next time.